What happens when a police officer makes a traffic stop outside their legal jurisdiction and ends up finding drugs and a gun? In this intense courtroom showdown, a young football coach faces serious charges, but the entire case could collapse because of one critical detail. The stop itself may have been illegal. As the judge issues harsh warnings and the defense drops a legal bombshell, everything hangs in the balance. This isn't just about guilt or innocence. It's about whether the law was followed from the very first moment.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
Officers initiated a traffic stop after observing the defendant cross several lanes while failing to signal and almost causing a collision. Upon contact, the officers observed an odor of marijuana. The officers asked the defendant to step out of the vehicle and asked whether the defendant had marijuana inside. The defendant admitted he did have marijuana inside, as well as a firearm. During the search of the vehicle, the officers found a handgun in plain view on the driver's side floorboard, not in holster. And the officers also located 13 grams of marijuana under the passenger seat.
Got it. All right, Mr. Flores, I'm going to find that there's probable cause to go forward.
Wait, did you catch that? The officer who made the stop was actually outside her jurisdiction. And in legal terms, that's not just a technicality, it could be a deal breaker. Buckle up, because this defense argument is about to challenge the very foundation of this stop.
With your case, do you have a valid Texas driver license? Do you not?
I have a SR22 in place. My license was suspended.
Okay, you're not allowed to drive. Do you understand?
Yes, sir.
If I find that you drive, I will have a contempt hearing. It's possible you face another 6 months in jail. I'm going to have you sign an affidavit with me today, promising you that you're not going to drive. Do you have liability insurance in your name? Car insurance.
Yes, sir.
Okay. I don't want you driving until you have a Texas driver license. You need to call DPS, figure out what to do to get your license. I'm going to give you the phone number now, but it's time for you to get your license back. And when you show me that you have your license and that you have car insurance, I will happily allow you to drive. But until that point, do not drive.
Am I not allowed with the SR22?
No, I don't know what's going on with your license. I don't know if you've ever had a license. What's going on, Alex? Can you run it, please?
On the license?
Please.
Yes,
Yeah.
Your Honor.
I mean, I can't give you legal advice, okay? But as it stands, until you have a Texas driver license and liability insurance, don't drive. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you understand? This is...
Now here's where it gets messy. Marijuana smell, a firearm in plain view, and a suspended license. On the surface, that sounds like a slam dunk for the prosecution. Unless, of course, the initial traffic stop shouldn't have happened at all. Keep that in mind.
The condition of your bond. If I find that you have a weapon, I'm going to revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. Do you understand, sir?
Yes, sir.
How old are you?
26.
What do you do for a living?
High school football coach.
And I see it is not eligible, and it says it's a mandatory suspension due to driving with license invalid, as well as an SR suspension.
Okay, so you even have an SR suspension. You can't drive at all. So this is now a bond condition. If I find that you drive, I'm telling you, HE double hockey sticks to pay. You understand?
So I'm not allowed to retrieve my weapon back?
I'm ordering you now, while this case is open, not to have any weapons.
Yes, sir.
Okay? Here, Stephen, do you mind giving this to me, please? This is the number to the driver's license division to DPS. You need to call them in the morning to figure out what you need to do to get your license back. Don't call them at 9. Don't call them at 8. Don't call them at 1:02. You're never going to get through. You need to call right when the phone lines open, which is at 7 o'clock in the morning. You'll get through, give them your license number, and ask them what you need to do to get your license back.
Okay.
Once you do, I'll tell you, I'll take this off, you know?
Yes, sir.
Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to fill out an application for me. I'll take a look at it. And then, assuming you qualify, I'll give you a lawyer today. I'm going to have you sign this agreement with me today that you're not going to drive. And I want you to understand, Mr. Flores, I take this so serious. Don't drive. If you drove here, you can't drive home.
No, I didn't drive here. My father did.
All right, so I'll have you come up here, swear to us. May I have you go to Jamae, sign a reset, and then we'll have you fill out the application, okay? All right.
Bringing a shared code book at the moment. We may have to have you look at a couple interesting things.
Okay.
And this is on the Trevor Flores case, Judge, and I think you visited with that gentleman earlier. He's present here in the courtroom at the moment.
Okay.
But I got the case this morning. I've had a chance to do a kind of little bit of digging
Cursory.
into. Yes. And although we are still waiting for the bulk of discovery of the case, he's charged with unlawful carrying of a weapon following a traffic stop. And I've got a map that is kind of intriguing, I think you'll find, just with the way it's drawn. But he stopped by an officer with the City of Bel Air Police Department. And may I approach to just show you this?
That's courtroom code for you drive again and you're going straight to jail. No pit stops. Judges have zero patience for people ignoring bond conditions, and Flores just got a very loud, very clear warning.
Delineation. But he's pulled over going.
I know the area well.
Northbound. He's pulled over going northbound on 610 as what is described as makes an unsafe lane change. So he's northbound on 610, wants to get on 59 to go southbound, is erroneously in the wrong lane going northbound. The officer says that she has observed him makes that unsafe lane change, and that lane change is outside of the City of Bel Air Police Department jurisdiction. Now, we have a particular statute that governs whether officers can have the authority to make a detention of someone when they are outside of their jurisdiction, and that's 14.03 of
Their
their
PD can still stop someone outside of Bel Air.
not for, well, according to the code, it says a peace officer.
That would mean that any officer outside would never be able to do anything.
No, that's incorrect. There's a very limited exception, and that's what applies in this case. So it says a peace officer who's licensed and is outside of the officer's jurisdiction may arrest without a warrant a person who commits any offense within the officer's presence or view, other than a violation of Subtitle C, Title 7.
Okay, this is where it gets fun. The defense isn't arguing innocence. They're arguing illegality of the stop itself. And he brought props. A map, no less. Welcome to Legal Geometry 101, where a few feet outside city lines could change the outcome of a whole case.
Of the transportation code. So generally, any offense that an officer sees, he can arrest that person or detain them, as the way the code uses that term, arrest. He can detain that person. But when it's for a traffic offense, that officer is
It's not
required.
arresting him for a traffic offense, though.
Well, that was the basis for the stop.
Sure.
But the way the code contemplates arrest, it's any, and that's defined in, I think, in chapter 15. But arrest, as contemplated by the code, includes detention. And so this officer doesn't have the ability, where that stop takes place, to make that detention. That officer could detain him if he saw him committing theft, could detain him if he saw him committing an assault, can't for a transportation code.
But he stops him for whatever reason it is, right? Comes up to the car and he smells marijuana,
Yes.
right?
Well,
And
that's
then
what-
don't they even get a drug sniffing dog? Is this the one where they get a drug sniffing dog and they find the weed? And
No, Your Honor, that's it.
was that a different case?
No, it's a different case, Judge. But the handgun, I believe, was in.
It was in plain view.
No, I think so I think what's alleged is it's in conjunction with possession of marijuana. And for purposes of just this limited PC question, my focus is solely the detention. I'm not.
It's certainly crafty. It's great. But he's not arresting him for the traffic offense.
Well, but I think we're looking at a limited scope of what arrest means. So I think you're looking at arrest as in
So
being arrested.
you would be saying that really if he had committed an ag rob, right? Or kidnapping, then even if he had kidnapped, like let's say he had a 2-year-old child in the car that he had kidnapped across state lines. Well, then according to this, because he's in a different jurisdiction, then you couldn't arrest him on that kidnapping charge too.
He saw a kidnapping taking place. The officer could arrest him under that code. But what he can't do is when there's a traffic code violation, we don't allow for example, the El Paso Police Department to come to Houston and then sit on the street corner and arrest people for traffic violations. We don't allow them to make those stops. And that's what's at issue here, is a peace officer who's outside of his jurisdiction able to enforce the traffic code.
I know where you're going and I've seen it before, but I'm not.
And we're looking at G1, Judge.
See the loophole? An officer can detain someone for a serious crime outside their jurisdiction. Think robbery, assault, but not for a traffic offense. So if this stop was just for a bad lane change, the entire search that followed might be fruit from a poisoned tree.
Where exactly did it occur anyways?
Let me see if I can pull up the address. We don't have like any discovery in this case, or how many dash cam or anything like that.
So what it says in there is 5600 610 northbound. And what's so curious about this is
That's still in Bel Air? Is it outside of Bel Air?
that would be outside of Bel Air too. And going northbound, southbound lanes are covered in the city of Bel Air. The northbound lanes, for some reason, are not.
I don't know. We'd have to look closer. I don't know.
Yeah, I'm
mean,
happy to
it's
look
something
further
that
into this.
You have to look. I mean,
can't make any-
I can't make that determination now.
Fair enough.
Number two,
Yes.
he's not arresting him on a traffic offense.
Well, and I think what the code contemplates when it says arrest, and I think there's case law on this, is that it includes the concept of detention as that's been, because I think when that code was written.
And so what I'm saying would apply as well, though. Like if he catches a 2-year-old kid, right, that's been kidnapped, by your theory, he wouldn't be able to arrest him on a kidnapping charge too.
Well, it's not my theory, it's the code.
If he has a dead body in the car, he wouldn't be able to do it.
Well, that's a legislature question. And I mean, but they wrote that.
I can't imagine that the legislature intended that. I think that they intended for a traffic, let's say for speeding, right? Or your tail light is out. Yeah, not to arrest in that respect. But he goes up to the car, smells marijuana, sees a gun in plain view. I can't imagine the legislature intended in that purpose.
And my position, of course, is that, this may be for a motion to suppress later down the line, and I think there's still
But
plenty more to do in the
it's
case.
a freaking awesome argument.
But the idea
I love you.
is
Mr. Wonderful.
no right to
Right.
detain him.
Right? Really?
I appreciate the judge, and we'll get.
I'm not ready yet, but build it. If you build it,
This case begins like a typical traffic stop, but quickly unravels into a complex legal battle over jurisdiction, constitutional rights, and the very limits of law enforcement authority. Mr. Trevor Flores was pulled over after allegedly making multiple unsafe lane changes without signaling, nearly causing a collision. Officers claimed they smelled marijuana upon approaching the vehicle and asked Flores to step out. He admitted there was marijuana inside, as well as a firearm. During a search, officers found a handgun in plain view on the driver's side floorboard unholstered, and 13 grams of marijuana under the passenger seat. On the surface, it looked like a solid case for the prosecution. But then came the twist. The officer who conducted the stop may have been outside of her legal jurisdiction. That revelation instantly shifted the courtroom's tone and transformed the legal landscape of the case. In Texas, peace officers are only authorized to detain individuals outside their jurisdiction if the offense witnessed is something serious, like assault, theft, or robbery. Traffic violations don't qualify. This distinction is critical because if the traffic stop was illegal to begin with, then everything discovered afterward, the marijuana, the gun, could be considered inadmissible as fruit of the poisonous tree. That means the very foundation of the state's evidence could be thrown out entirely. The defense zeroed in on this point, even bringing a map to illustrate that the lane change occurred in an area not covered by the Bel Air Police Department, where the officer was employed. The judge didn't dismiss the argument. In fact, he acknowledged it as a great and crafty legal challenge, signaling that it had real merit and could form the basis for a future motion to suppress evidence. But while this jurisdictional issue was unfolding, the judge turned to Flores and issued a stern, uncompromising warning. Regardless of how clever the defense might be, Flores was not to drive under any circumstances. His Texas driver's license was suspended. He was operating under a state Route 22 insurance policy, and he was not legally permitted to drive. The judge told him point blank, if he drives again, he will face contempt of court, his bond will be revoked, and he will go to jail. No more personal recognizance bonds, no more second chances. The court even had him sign an affidavit agreeing not to drive until he had a valid Texas license and liability insurance. The judge handed him a phone number to the Department of Public Safety and instructed him to call exactly at 7 a.m., not 8, not 9, and certainly not after 10, because otherwise, he'd never get through. He told Flores to speak with DPS, find out what he needed to do to reinstate his license, and only then would the judge consider lifting driving restrictions. At the same time, the judge issued another bond condition. Flores was not allowed to possess any weapons while this case was active. When Flores asked if he could get his weapon back, the judge was clear, absolutely not, at least not while the case is pending. Flores, a 26-year-old high school football coach, assured the court that his father had driven him to court that day, which the judge acknowledged as a good first step. The court also processed his application for a court-appointed attorney, noting that he may qualify after a brief review. Meanwhile, the assistant district attorney reiterated the state's position. While the stop may have been initiated outside jurisdiction on a traffic violation, it escalated when marijuana was smelled and a firearm was seen in plain view, arguably enough to justify continued detention and search. But the defense shot back that the officer didn't have legal authority to make the stop in the first place. Under Texas Code of Criminal Procedure Article 14.03, an officer outside of their jurisdiction cannot detain someone for a transportation code violation, only for criminal offenses. This put the entire stop under the microscope. The judge leaned into the debate, presenting hypotheticals. Could an officer outside his city limits stop someone for kidnapping? For having a dead body in the car? The defense argued that serious offenses, yes. But for speeding or an unsafe lane change? Absolutely not. The judge acknowledged that the law seems to support the defense in this regard and remarked that it's a legislative issue. The code is clear. While it's unlikely the legislature intended to protect people with guns and drugs in their cars, the reality is, the wording of the statute may very well lead to suppression of all post-stop evidence if the stop itself is ruled unlawful. This, the judge emphasized, is no small technicality. It's the kind of legal question that could decide the entire case. Though he didn't make a final ruling at this hearing, the judge indicated that the matter would likely be revisited through formal motions in the coming weeks. In the meantime, Flores walked out of court with strict marching orders. Do not drive, do not possess weapons, and call DPS to fix your license. Violating any of these bond conditions would land him behind bars immediately, and the judge made it crystal clear there would be no patience for excuses. In closing, this case, which began with a routine traffic stop, has evolved into a constitutional showdown about police power, geographic authority, and whether due process can be bent by proximity. The stakes aren't just about drugs or guns anymore. They're about whether the rule of law itself will hold up when lines, both literal and legal, are crossed.